Hello. I would like to talk to you a little bit more today about employment discrimination. A bit of review, I think, is in order here. Very important employment discrimination law is Title VII of the Civil Rights Act of 1964. So I do want to remind you there are basically 5 categories or 5 protected classes here under that law: sex, race, color, national origin, and religion. And there are 3 types of discrimination: disparate treatment, disparate impact, and retaliation. Disparate treatment occurs when an employer intentionally discriminates against someone because of their sex, race, color, national origin, or religion. However, there can be a defense or an excuse by that employer if it is a BFOQ. But race or color can never be a BFOQ. Disparate impact is when you have a seemingly neutral type rule or test or whatever, but it has a discriminatory effect upon someone who is protected under one of these 5 categories. And there is a defense to that also. In some cases, it is a business necessity. And then the third type of case is retaliation, where there is an adverse employment action against an employee who has either accused the employer of a violation of this act or somehow participated in supporting an employee who has accused the employer. Employment practices that may be challenged include things like testing and educational requirements. You may need to make sure as an employer that all testing and educational requirements are job-related and necessary for the business. So you can't say, well, I want everyone who is cleaning my office to have a master's degree, because that may have a discriminatory or a disparate impact on certain groups of people and who are protected under Title VII. In addition, height and weight requirements are another one. If you're using height and weight requirements, that may discriminate based on race. It may discriminate based on sex. And again, you need to be able to demonstrate as an employer that the requirements are validly related to the ability to perform the work in question. And they need to apply equally to all applicants. Now, appearance requirements can be tricky. Many companies set grooming standards for their employees to maintain a good image, but sometimes these things may discriminate. For example, saying that someone cannot have a beard or must wear or cannot wear certain headwear or whatever may be illegal. But there's some confusion by the courts and rulings both ways in connection with some of those appearance requirements. Affirmative action may also be challenged. Affirmative action is when a federally contracted employer must hire members of minority groups when there are fewer minority workers in a given job category than one might reasonably expect, considering their availability. Courts will impose those types of plans on employers to overcome a history of prior discrimination, but sometimes private employers voluntarily adopt those affirmative action plans or to agree to it with unions. The problem then is affirmative actions can give rise to reverse discrimination cases. For example, where white males may choose to sue, saying we are discriminated against as white males because of this affirmative action plan. Seniority systems give priority to those employees who have worked longer for a particular employer. An example would be in the city of Memphis. There was an employer, a city employer, who had historically had mostly a white workforce. Then when they engaged in affirmative action, they began to balance the workforce with more African American workers. Younger workers had more African American employees, the younger workers. The older workers were mostly white. Well, when it was time to lay people off, the concern was there's a seniority system, which means that mostly African American workers would be laid off. And the court said, even though there's an affirmative action plan and having a seniority system may have the effect of discriminating against a protected class, a good faith seniority system will be upheld in spite of the fact that this may be somewhat have a disparate impact on certain groups, as long as there's no intention to discriminate. Now, there's another law, Civil Rights Act of 1866, right after the Civil War. It complements Title VII of the 1964 Civil Rights Act. It says all persons shall have the same right to make and enforce contracts as enjoyed by white citizens. It bans racial discrimination in union memberships and employment relationships. There's also the Age Discrimination in Employment Act, which protects employees or applicants against discrimination based on age, but it only protects people aged 40 and above. So there's no protection for people under age 40. It prohibits mandatory retirement. It invalidates retirement plans and labor contracts that violate the law. And their remedy is back pay and recovery of attorney's fees. And if there's willful violation, the victims are awarded double. Another anti-discrimination law is the Americans with Disabilities Act of 1990. It helps people with disabilities to get work and prohibits employers from requiring a pre-employment medical exam or asking questions about the applicant's medical history. A disability is any physical or mental impairment that limits an individual's major activities. Now, there are major life activities could be seeing, learning, hearing, walking, those types of things. Not included as protected disabilities are homosexuality, sexual behavior disorders, compulsive gambling, kleptomania, and disorders resulting from current drug or alcohol use. Although a recovered or recovering drug or alcoholic abuser is protected. All right. So what does the employer have to do? Well, they have to give a reasonable accommodation to a qualified employee. So basically, employers are not required to undergo undue hardship to adjust the job or work environment, but they do have some reasonableness requirement to adjust the job or work environment to fit the needs of a disabled employee. Also, there must be reasonable accommodation of customers and others. If this is not done, then there can be hiring, reinstatement, back pay, front pay, injunctive relief, compensatory, and punitive damages. There's also the Genetic Information Non-Discrimination Act, prohibits covered employers from discriminating against individuals on the basis of their genetic information. There is HIPAA, which deals with discrimination in health insurance. This prevents discrimination against individual employees and small businesses. And the Affordable Care Act prohibits insurance companies from refusing to cover individuals based on pre-existing conditions. In addition to all these other laws that we have discussed, do note that there are state anti-discrimination laws. The Federal Equal Employment Opportunity Act prohibits state laws imposing additional duties and liabilities, and protects categories of persons not protected under federal law. It does supplement Title VII by offering remedies to victims of sexual harassment, and torts and discrimination plaintiffs can sue employers under state laws. Keep in mind, we've talked about how for the Title VII of the Civil Rights Act to apply, you need to have 15 or more employees. But state laws about anti-discrimination can prohibit discrimination even when employers have fewer than 15 employees. So do keep in mind that that can be an issue. Even if you're a small employer, you do need to avoid discrimination that's illegal. Thank you very much, and have a great day.